Hello, I am Emily Sumner live once again, and today we are talking about the marriage-based green card process for professionals. I practice and our team practices employment-based and family-based immigration law, so a number of our clients are here in the United States already on some sort of professional visa, whether they are foreign national students who have completed their degree and they're working on optional practical training, which is OPT or STEM OPT. They may be here on another visa classification, such as the H-1B, the L, and E, TN, any number of different visa classifications. Or some of our clients are professionals working overseas. They come to visit their loved one here in the United States, decide to stay and apply for the marriage-based green card. So let's talk about the ins and outs of all of these options. What are the challenges that are unique to professionals and ways that they can make sure that they're addressing them and reducing the stress for the couple involved in the marriage-based green card process. So, as I said, there may be any number of situations in which a couple who is a professional couple, busy careers, may or may not have children, but busy careers, just busy in general, lots of stressors, and they are looking to start the marriage-based green card process. As I said, there can be several different situations. If a person is, or if a couple is in a situation where the foreign national spouse is currently in the United States on OPT, optional practical training, or STEM OPT, which is an extension, a 24-month extension that they may be eligible for, then they are probably looking at multiple options. The couple may not even be married yet, and that could be true for any of these options or any of these scenarios. But the couple could be not be married yet, kind of weighing their options. So a lot of times when I talk to couples in this situation, the foreign national couple or foreign national individual and his or her significant other are looking at options such as the H-1B lottery. And we know from other information, I've done a live about this before a little bit last week about the H-1B process, the chance of being selected in the H-1B lottery is maybe not great. Hopefully it'll be better this year with the change in the registration system, but still there's not a guarantee that you're going to be selected in the H-1B lottery. So people on OPT or STEM OPT are looking for ways, exploring multiple options to stay in the United States long term. So like I said, that can include the H-1B lottery. It could be that they're looking at the possibility of a J, which could come with the 2-year home residency requirement. If they qualify, they could be looking at the O. If they qualify, they could be looking at an employment-based green card option, which is great, but that probably will not allow them to stay in the United States long enough to continue working without a gap in their work authorization. It's a complicated situation. Every situation is different. But in general, an employment-based green card is not going to be the magic answer just because of how long it takes. So a lot of times when I'm having conversations with these foreign nationals in these situations, we also talk about the marriage-based green card process and what that would look like in terms of the process, in terms of timelines, and that type of thing. Almost always when I have this conversation with couples, I say, first of all, don't get married if you don't plan to get married. You know, you can't do this just for immigration purposes. Of course, it has to be because it's a bona fide relationship. But the couples that I'm talking to, it is a bona fide relationship and they do plan to get married. It's just a question of timing about when they plan to get married. So a lot of times when I'm talking to couples in this situation and we're talking about the marriage-based process, I say, go ahead and get married now. Start the process now, because a big concern for individuals in this situation is they don't want to have a gap between the end of their OPT or their STEM OPT and the time that they receive either their green card or their employment authorization document, which is the EAD. So let's talk about processing times for all of this. The marriage-based green card process involves a lot of different forms, a lot of different boxes that you have to check, a lot of information that you have to submit. We are here to walk you all through that process. And we complete all of that for our clients and make sure that everything is done correctly the first time, the first go around. But in terms of processing times, once we submit that application, the processing times for the EAD, the employment authorization document, a lot of times our clients will receive it within about 6 months, but that is not guaranteed. You look at the USCIS processing times and they are on the website and they are all over the place. So it absolutely could take longer than 6 months. So for example, we recently filed a marriage-based green card case for a couple where the foreign national is on OPT. The OPT expires in August. They were planning to get married this spring and thought, oh, 6 months, that's plenty of time. I said, no, get married now. And they were willing to. They got married, just had a civil ceremony. They'll have a different celebration later down the road, which is totally fine, but they got married. We were able to file before the end of last year, before the end of the new year, and the foreign national spouse is in a really great situation to have that EAD, the employment authorization document based on the green card in hand well before his OPT expires, which is amazing, reduces a lot of stress for both of the members in that particular marriage, both the spouses. So we were happy to be able to do that. But my point is file sooner rather than later. You don't want to wait until you have 3 or 4 months left on OPT or STEM OPT and then try to be figuring out what your options are and realize it's going to take longer than you expected. Like I said, the timelines are not guaranteed, even though we are seeing typically that the EADs or sometimes even the green cards themselves are taking close to 6 months. That's absolutely not guaranteed. And we absolutely have cases that are taking longer, and it's out of anybody's control, really. It is possible to ask for an expedite request, but it's not guaranteed that that's going to be approved. So my point is plan ahead, start the process as soon as you possibly can to reduce that stress and ensure that you're able to keep working and keep your position without an interruption in your work authorization. So that's kind of the first big group of individuals I wanted to talk about, individuals who are on OPT or STEM OPT, looking at all the different options. We do have a number of clients right now who are considering registering, having their employer register them in the H-1B lottery. They have significant others that they plan to marry at some point down the road, but depending on the outcome of the lottery, it may be sooner rather than later. And again, these are absolutely bona fide relationships. This is not a situation where they're getting married just for immigration purposes. That is absolutely prohibited and can get you in a lot of trouble. So don't do that. But it is a consideration. It's something to keep in mind. The second big group of individuals that I'd like to talk about is individuals who are already here in the United States in some sort of temporary non-immigrant visa status. So for example, we have a number of marriage-based clients where the foreign national is working on H-1B or L1 or E or TN or H-1B1, any number of those different visa classifications. And again, my advice to them, and I can't give legal advice on this form, it has to be, something specific in a consultation or for a client. But my advice generally is start the process sooner rather than later. A lot of times the person who is the foreign national spouse who is on H or L or whatever the visa classification is, they want the flexibility to be able to change jobs sooner rather than later. They may not plan to, they may not have specific plans to, but they want that possibility. Or if heaven forbid they're laid off, they want the possibility to or the opportunity to be able to find a different job without having to be sponsored for that particular work visa. So again, in situations like this, I'm telling clients in general, start the process sooner rather than later. Again, in terms of processing, it's the same as what I said before, the processing timelines. It's roughly 6 months. It absolutely can be longer than that. It can be shorter than that. In general, and this varies a whole lot, so I hesitate to say it, but we are seeing right now green cards, marriage-based green cards like this are going incredibly quickly. They're being processed quickly, relatively speaking. So it used to be that cases like this would take at least 12 to 18 months, if not longer. And we do have cases, to be clear, we do have cases that have been pending since 2022. I don't think we have any older than that, but that have been pending a long time. So it's definitely inconsistent for sure. But we have so many clients that we have filed and they are approved. The marriage-based green card is approved within 6 to 9 months. In this situation, the file is well documented. It's not over documented. You don't want to present, 1,000 pages of documentation of your relationship, but it's well documented. A lot of times the client is able to provide the medical exam, submit the medical exam up front so that there's not a request for evidence for that. And it's well presented, it's well organized, and it's the file shows that the couple meets all of the elements that are required. So in those cases, a lot of times, not always, a lot of times the cases are approved within 6 to 9 months and the interview is being waived. That's key. If your interview is not waived, that does not necessarily mean there's anything wrong with your case. But the fact that USCIS is now waiving interviews in general means that they are able to adjudicate these cases a lot faster because they don't have to have these meetings with every single couple that files. So we really appreciate that move from USCIS. And we're glad that they're able to still keep up the integrity of the program, but not have to interview every couple. So again, timelines, you may receive either the employment authorization document or the green card within 6 to 9 months, no guarantees. Could be longer than that. And we, like I said, we definitely have cases where it's taking longer than that. The other group that I wanted to talk about, and to go back to that group for just a minute, the individuals who are working here on H or L or E or TN, whatever the classification is, like I said, a lot of times they want that flexibility to move. Talk to your immigration lawyer about that before you make that decision to use your EAD based on the green card filing to work. Talk to your immigration attorney about that. I typically recommend, and again, this is not legal advice, but I typically recommend that clients maintain their underlying status as long as they can, just in case there's something that goes wrong with the green card. We don't anticipate that for the majority of our filings. We tell people proactively if we do. But in general, we don't anticipate that it's going to be denied. But we have seen 2 erroneous denials of green cards this year, and we were able to get it addressed and overturned without a problem. But that's always a possibility, and it's nice to have that underlying status to fall back on. But like I said, it's also nice to have the option if the company has layoffs or whatever the situation is. It's nice, again, to be able to reduce that stress and know that you have a fallback plan. The last group that I wanted to talk about today is the group of professionals that maybe are working overseas. So we have a number of clients where the foreign national comes to visit the United States. They come to visit their loved one here in the United States on, let's say, a visitor's visa or ESTA. While they're here, they change their mind and they decide to go ahead and get married and stay and apply for a green card. That's its own issue. So it is not permissible to enter the United States on a visitor's visa or ESTA with the intention of staying and applying for a green card. It's all about your intent at the time of entry. Again, speak to me or another qualified immigration attorney about it to make sure that you're doing this correctly. But if you're here and you change your mind, which happened a lot over COVID when people got stuck here in the United States, unexpectedly when COVID first hit, but it also happens now that people come to visit. Then they talk with me, for example, about their immigration options, and they realize staying here really is the best option for them. In that case, there's always the question, what about work authorization? So timelines are the same, regardless of which of these 3 categories you fall into, whether you're working on OPT, a non-immigrant visa, or you're here visiting. The work permit timeframe is still going to be the same, roughly 6 months, give or take anywhere from an additional few months to indefinitely. And by the way, a lot of times the green card is approved before the employment authorization document and before the travel document. If that happens, then you use the green card. The immunization document and the travel document are interim benefits, meaning they're designed for you to use just while the green card is pending. Once you have the green card, you work and travel using the green card. So the question with these individuals is, can I continue working in the United States for my overseas employer? Again, can't give legal advice here. That is a gray area. My stance on that, I tend to give very conservative advice. My stance on that in general is that no, it is not permissible to work in the United States, even if it's for an overseas entity. You will find immigration attorneys who disagree with that, who say, yes, it's fine because it's an overseas entity. It's not a US entity. Again, it's a very gray area, but that is something to consider if you are a professional couple looking at the marriage-based green card process and making your decisions, talking through your options about whether to file while the person is here in the United States visiting and have changed their mind once they've entered the United States, or whether you're going to have the foreign national spouse leave and then process at home, which takes a while to get through and means a long distance relationship, potentially, unless the US citizen or LPR spouse is able to move overseas. Anyway, that is a consideration, is are you able to continue working? Do you need to continue working while you're here in the United States? And you really don't have permission to do that until you receive that work authorization card. And again, that process is usually going to take 6 months, could take longer than that. The other consideration for all of these classifications, but I find it comes up especially with couples where the foreign national is here visiting on ESTA or a travel document, they want to be able to go back home, which I totally understand. I'm a homebody. I would get it. I would want to go back home as well. But you cannot travel once you have filed the I-485, the application for adjustment of status. You can't leave the United States. There's an exception that I'll talk about, but you can't leave the United States until you have the travel document. It's called the advanced parole document. Sorry, advanced, not advanced. Advanced parole document that allows you to travel. Once you have that, you can leave. You have the potential to leave, talk to your immigration attorney before you travel, but you can leave the United States and re-enter without abandoning your I-485. If you're here visiting, or if you're here on an F1, for example, and you leave before you have that travel document, then you have abandoned your application and it will be deemed abandoned and denied, basically. Again, there is an exception for individuals that are traveling on, who hold valid H or L status. Talk to me about that if you are in that situation. It's a fact-specific situation and I can't give legal advice. I know I keep saying that, but I can't. But just know that there are exceptions for individuals on L and H where you should be able to travel before you have the advanced parole document. So that is the information that I have for this week about the marriage-based green card for professionals. If you have questions about this process, about an employment-based process, a family-based immigration process, we are here to help. We are here to provide excellent service with empathy and to help clients have a less stressful, not stressless, but less stressful experience. You can reach us at info@sumnerimmigration.com. Make sure that you follow us on the platform that you're watching this on to catch our next video. Until next time, I'm Emily Sumner with Sumner Immigration Law.